Welcome to You and the Law. I'm Steve Cilente.
And I'm Bob Lally.
I like our new casual appearance, Bob.
It's cooler.
I've never understood why in the legal field men have to wear ties and coats, especially when it's hot in the summer and it's 100 degrees outside and you're wearing a coat.
True. Occasionally a judge will say you can take your jacket off, but not roll up your sleeves and take your tie. So it's warm. So.
Not enough. Today we're going to talk about landlord-tenant issues. Whether you're a landlord or a tenant, this is a show you want to listen to. Even though we're going to talk about some of the very basic parts, this is something hopefully you can learn. Maybe you never want to be a landlord or a tenant for that matter. We're not going to be able to cover everything, but we're going to try at least highlight some of the areas. First thing is, can a landlord evict a tenant?
Yes, a landlord can evict a tenant. However, there are limited circumstances in which a landlord can evict a tenant. And those are?
First of all, the one where you see probably most often is the tenant is not paying their rent. And obviously, certainly given today's economic situation, we see that a lot. But it also could be if the tenant is under a lease, they're breaking the terms of the lease, or they're breaking the terms of the rental agreement.
Becoming a nuisance?
They're not fixing a problem. For instance, they've got a pet. They're not supposed to have pets, or they're causing some damage to the property and running the property down.
Doing something illegal on the property, maybe?
Absolutely. Creating a nuisance, disturbing all of the other neighbors, any number of things that a landlord can say, you get off of the property. But there is a process to do this.
There's a process to everything in the law.
Absolutely. First thing there has to be is written notice. If the tenant doesn't do what the notice asks, then the landlord can file what's called an unlawful detainer. And that's the court process.
That's when the notice period ends, so they have to serve the notice first. Am I correct about that?
Well, it depends, yes and no.
Okay.
But the process we'll get to it. But the action is really called an unlawful detainer action. And that's what will start the court process.
Interesting.
And that's a lawsuit where the landlord is actually telling the tenant, you've got to get out. And of course, if the judge agrees with the landlord, the tenant goes. In fact, the sheriff can actually evict physically assist the tenant in leaving the property. And of course, if the tenant wins, they're not going anywhere. But certainly, the unlawful detainer, that's a court action where the court is making an order that the sheriff has to follow. But it doesn't really start there.
Where does it start?
It starts, you have to go back a little bit further, and first of all, can they evict a tenant without any court action? They can. But again, you have to have two cooperating parties.
Well, that's when we talk about common sense and two people agreeing.
Exactly.
Yeah.
Now, understand that we're going to talk about quit or pay rent issues, but one of the things we run across a lot of times is we call self-help, where the landlord decides they're going to do their own thing. They don't need the court to do it for them.
That might cause a problem, wouldn't it?
That's where you come into play.
Okay.
Because when a landlord does it wrong, they may have the tenant may have a civil action, certainly against the landlord. Landlords cannot physically remove the tenant. can't get rid of their property, can't lock the tenant out, cut off the utilities, the water, electricity. We've seen that a lot where they go out and they'll pull the PG&E meter or go turn off the water at the city street or the town street. They can't remove outside windows and locks.
That's right. What about the changing of the locks?
They can't do that, and we've seen where they actually remove the doors. And of course, that's when the landlord could end up with some real problems. Now, there's a difference, of course, if there's a written or an oral agreement regarding the house. Being lawyers, we like things in writing. But when we're dealing with things that are oral, they're usually month to month, correct?
Correct. Yes, and the terms usually carry over from month to month.
Right. And of course, there's a problem if not everybody has a clear understanding of what those terms are. So how does the notice start? And of course, they have to serve the tenant. It's got to be somebody that's over 18 years of age that does the service. Now, unlike some areas of law, that the person bringing the action cannot be the person serving. We see that in family law. The husband and wife, they cannot serve each other. They've got to have someone else. They've got to be an adult. They don't have to be a citizen. But in this case, landlords can actually serve the tenant.
I was wondering about that. I was really wondering because we go to such great detail to make sure whoever is serving it is not a party to the action that why this exception. I don't want to get into it. I know you have a lot to cover here, but...
Quite honestly, I don't know the short answer to that. And it may go back to the older days where you had hotels and motels or boarding rooms and so forth. I don't know. I did not research that part. Now,
that's one important thing. Lawyers don't know everything.
No, we think we do, though. Now, there are two types of service that we see all of the time. There's personal service and substitute service. What are they, Bob?
Well, personal service is where the person is actually personally served. You come to the person, you personally hand it to him. You don't actually have to hand it to him. You could lay it, lay it next to them as long as they've identified themselves and they have some indication as to what it is. Now, substituted service is you made a couple of tries at the house and maybe over a period of a couple of days, you've been there a couple times and the person just isn't there, or at their business, you leave it with somebody that's at the house, you get their name, or at the business, somebody apparently in charge of the business, then you have to mail it, and it extends the time somewhat to what they have to respond.
In other words, you're serving someone other than the actual tenant, maybe a guest of theirs or spouse.
That's right, and that's why the extension of time and response, because it's a little less reliable that they personally got it.
Now, in landlord-tenant, they've also got another way of service that's unique to landlord-tenant, and it's called nail and mail. That's where they literally can nail or post the eviction notice on the front door, and then, of course, they have to mail a copy. One of the big problems here is sometimes we don't have home delivery. We have post office boxes, so the landlord may be in trouble as to where to nail and mail.
That's interesting.
Well, we do run across that quite a bit. We see that in criminal law cases where the court has mailed a notice that a person's got to come to court. They'll put a physical address on the envelope when there's no home delivery there. It's strictly post office box. And sometimes it's because someone didn't read the citation or something and didn't see that there's actually a post office box, or the law enforcement officer didn't write down the mailing address. Cities, it's not much of a problem. Here, yes, it is.
What do you think of this idea? Let's say there's a P.O. box and physical address and mailing it to both.
Say that again?
Say there's a P.O. box and a physical address.
You can send both.
Yeah, that's what I'm thinking.
I often have, where you're not really sure, or you may want to talk to somebody that knows for sure where they're actually getting their mail. But if you're like some of us, you got a post office box, you only check it once a week, every 2 weeks. So, now, what kind of notice does the landlord actually have to give notice? Now, this is a real difficult area of the law, and it's not really easy to explain what kind of notice is given in each case. So, what do we always recommend?
See a lawyer. And maybe I can ask you a question and pretend you're my lawyer. How about this? So I can say, what is a 3-day notice?
Well, first of all, I want to check for my retainer. So Now, there's a 3-day notice. You get different kinds of notices. First of all, you get a 3-day notice to pay rent or quit. And that's exactly what it means. Your rent is due on the 1st. On the 2nd, they give you notice to pay or quit. That means pay within 3 days or they'd like you to leave. Does that normally happen? Well, people do pay, but do they leave in 3 days? Not normally. But this is the type of notice that landlords typically serve when a person's behind in their rent.
You're probably getting to it, but I have a question here. Let's say that they haven't paid within the 3 days, but they tender the money. Tender means give to the landlord at a later time after the 3 days.
All right, let's say it's due on the 1st. Oftentimes what you'll see in writing is it's due and payable or due on the 1st, but payable no later than the 5th. It's on the 6th day, assuming we're talking about the 1st of the month, 5th of the month, so forth. On the 6th day is when the landlord will serve the quit or pay rent, or rent or, either way, rent or quit. But if you bring the landlord the money on the 10th day, the landlord can say, I'm not going to accept it. You're out. But if the landlord does take the money, they may have stopped any further action for that month because they went ahead and accepted the money. Can you tell the landlord you take it? You have no choice? You can say it, but that's not necessarily true. The next way is we call notice to perform covenants or quit. Now, Bob, got an idea what that is?
Well, I'm thinking that it has something to do with the responsibilities of the tenant in maintaining the property or something, and the promises that the tenant says he'll do, and they're not doing it.
Exactly. That's where you look at your lease and it says no pets, and you bring a pet in, they can tell you either fix a problem or you're out of here. There's a very similar one called notice to quit. And again, it's kind of, you're not following tenants, you're the tenants of the contract, not different kind of tenant. The clauses, the rules of whatever the contract is. You're creating a nuisance. Maybe your tenant is selling drugs. There's some other health and safety issue. And under the law, we have a special definition of waste. But essentially, it's the same thing. You're doing something to the property that lessens its value. You're creating, legal term, waste.
The landlord would have to be prepared to do that with appraisals. I'm just kind of curious about that.
I'm not sure what you mean by appraisals.
Something that would lessen the value of the property? Is that would be a...
Well, let's say, for instance, the landlord sees in their apartment building that some tenant is changing oil in the parking lot and letting the oil run across the parking lot.
That'll do it real quick.
Very quickly. Yeah. There's a lot of laws that cover hazardous waste.
Exactly.
And the landlord can say, either you cease or you're out. Or they can, in fact, say, you're out of here.
That could also be a thing of a notice to covenant to quit doing that, right?
That's why leases and writings are nice to say there's certain things you don't do. And I know in a lot of leases that I've seen over the last few years, we're starting to see some very specific issues regarding hazardous waste addressed because it causes such a problem. And again, we're not going to get into that, but you may be talking about digging up a parking lot and 3 feet of soil and disposal of that outside of the area. Very expensive when you're talking about hazardous waste. And we also see 30 and 60-day notices to quit. Now, this is typically when we see a month-to-month tenancy. In other words, I just want you out of here. And these are month-to-month tenancies of less than 1 year in length. They just want you out. It may be because they're going to refurbish the house, rent it to a family member, sell it, whatever. They really don't need a reason. They would just like you to move.
Now, that doesn't have to be a 60-day notice unless the rent's being paid every 60 days. It could be a 30-day notice, right? I mean, it could be, the earliest it could be is 30 days, I understand.
Most often you see 30-day notices, but there are some instances where they may want to give the tenant more lead time, so they'll give them 60 days.
Oh, I see.
And there is one instance where there's actually a notice to quit that's 90 days long, but that's typical of Section 8 housing. different laws when you're dealing with Section 8 housing, and that's certainly a good area where you want to talk to an attorney that does landlord-tenant. And I'll tell you that it's kind of hard to do, because in talking to a lot of different lawyers, representing tenants is a little low on their list, because unfortunately most of those cases don't have the best outcome. Most often you'll find lawyers that will typically represent landlords because they usually win those cases. So, are there any type of cases that are really not suited for landlord or unlawful detainer?
Well, that's situations like where the tenant wants the landlord to fix something. You know, there are other remedies for that, like taking it and putting it in a trust account and holding it for the. But that goes beyond this. But that type of situation, or a tenant moves out and landlord, for unpaid rent, he's seeking that, and deposits, things of that nature.
The issue where the tenant wants the landlord to fix some things, I believe they're called 1963 actions, and I'm going way back in my memory to draw that out, and I may be completely wrong. There are certain things the landlord must do to make a house livable. For instance, a vandal comes and breaks out all of the windows. Whose responsibility is to fix it? And my recollection is it's really the landlord's, because that's a health and safety issue. Same with heat and air conditioning or cooling, making sure there's power at the house. There are certain responsibilities the landlord has under the law, irrespective of what the lease says, unless it's a commercial lease, of course, that a landlord has got to keep a house where it is habitable.
Something just occurred to me in this, kind of new era we're living. Fire alarms. I was
Yes.
wondering if they're required to have that.
Well, let's say you're renting a house in the country, and I believe, and I may be wrong on this, but the forestry says you've got to have a cleared area 100 feet from the house and maybe 100 yards for all I know right now, since I live in town. But if forestry says you've got to have this area cleared, it's not the tenant's responsibility. It is the landlord's responsibility.
Interesting. I did not know that.
So now the question then becomes what if the landlord doesn't do it? What are the options that the tenant has? Is self-help a remedy, or just moving?
No, I think one thing a tenant could do when you talk about self-help is maybe, you want to be careful because you might damage some of the property, some of the trees or something. So
there are a lot of issues involved in that.
I'm just thinking it's a touchy area there.
Right. If you're in a situation where you live in the country and CDF comes along, or CAL FIRE now, says that you've got to have so much of the property cleared to save the structure, keep the structure from getting on fire, that's definitely an area you want to talk to a lawyer about, is whether or not your responsibility as a tenant or your responsibility of a landowner, what happens if nobody does it. And certainly CAL FIRE, if it's regulated, can issue a citation, and normally that does go to the landlord. But that's definitely an area that you want to talk to a lawyer about. Now, we've gone beyond the 3-day pay or quit. Mm-hmm. The tenant hasn't paid their rent, or whatever the nuisance is, or whatever is still there, it's not being resolved. Now we start the unlawful detainer action.
The actual filing?
The actual filing. Once it's filed, how long is that going to take?
I've heard that it takes about 30 days. Is that correct?
That's pretty close. Now, it depends, of course, on the court's calendar and so forth. But remember, we get into these special rules. Just because you filed it on day 1, if you don't serve it till day 20, the time may not start until day 20. So they've given it 30 days. Timing is very important. Again, that's why you need to talk to a lawyer. That's why if you're going to do self-help, do some homework to figure out exactly what you can and cannot do. We're back into the personal service issue. Now, when you're doing the unlawful detainer, you may not be able to do the nail and mail. You may have to have actual or personal or substituted service. So you've got to talk to a lawyer. Certainly you can go to the court. See if they've got information on doing landlord-tenant items. You can go to the court's website under self-help. There's a great section on landlord-tenants from both the landlord side, the tenant side, but in the end what they ultimately say is go talk to a lawyer. But assuming you file or you serve right away, the tenant's got 5 days to file a response, and you may be in court within 20 days of the actual date of service. So these things can move very, very quickly.
I have a question about that, but one question that occurred to me, and that relates to a question earlier. Say if a house is in foreclosure, can a landlord use an unlawful detainer action to get the tenant out, evict the tenant?
Absolutely. That's exactly what they do.
If the house is in foreclosure?
Oh, all right. I was
Yeah.
jumping ahead a little bit. Foreclosures are an entirely different issue. But let's say I'm a landlord, I'm losing my house. I can certainly tell the tenant, get out. Okay, go through the 3-day notice, serve them an unlawful detainer, and tell them to get out. There's some real special rules that apply once the house goes into foreclosure. Without getting really in depth with it, once a house goes into foreclosure, let's say you're the tenant living in a house, you just got notice that this house that you're living in has just been foreclosed on. What are your rights? Again, very special rules. After the house is sold at foreclosure, if it is in fact sold, you may have up to 90 days that you can continue in the house, because I think it's 90 days. The owner who lost the property has a right to actually buy the property back. Now they come up with the money. They've settled with the bank, you're fine. But they've got 90 days to do that. In some situations where at the foreclosure sale, they don't get the bank doesn't get the amount of money they're looking for, you may have months that you can be in the house. It may be extended, I think, out to as much as a year. Again, if you're in that situation where you're the tenant, you just found out that your landlord, the owner of the home, has lost the property, you need to do some homework, and very quickly, so you don't find yourself basically being out on the street because you didn't figure out what the law was that's going to apply to you. So let's say that we've got the unlawful detainer has been filed, you got to court, the tenant lost. How much time is the court typically going to give them to move out?
Well, everything happens pretty short in these cases, about 5 days, as I.
Right. But we do see, of course, is that sometimes the court, while the parties are both there, asks the landlord, all right, they're going to move, why not give them 2 weeks? Of course, the landlord can say no.
But you usually see them try to cooperate with the court.
Sometimes.
Sometimes that's true.
But literally,
Yeah.
let's say that the person, and the law is 5 days, as I understand it, the person says, I'm not moving. What can happen?
We have a trial.
No, we've been through the trial.
Oh.
The judge already ruled.
Oh, okay. What happens is that you have a court order now after the trial, and that's going to be given to the sheriff. And that sheriff has the authority to come and actually, and I think this is where they give them about 5 days, but they can actually physically take their things out of the house. Am I correct about that? It's called the eviction?
That's my understanding. Again, I don't do landlord-tenant, and I know, as we say in the law, I know just enough to get myself in trouble. So if somebody calls about a landlord-tenant issue, I tell them the same resources I'm telling you. Get online, do some homework, check the court's website, and try to find the answer and find an attorney that handles that. You can go to the Calaveras County Bar website. All the lawyers, the local lawyers are listed. These are the people that are, for the most part, in town. They're not just a name that they buy advertising space for. We always say, get a lawyer. And certainly if you're a tenant, get a lawyer. Landlord should do the same, correct?
Well, yes, absolutely should do it. But, you know, you could go to the self-help with this, but there's a lot of rules and regulations that if you don't follow this one, like step by step by step by step, it's not going to work.
I've seen some situations in some types of cases If you don't put a check mark in the appropriate spot, you may find yourself one either out of court or having to start all over by redoing your paperwork and have to reserve. And you end up losing time. And with landlord-tenant, some of the lawsuit, that time is time that you may not want to lose. So always, if you can, talk to a lawyer, get their assistance. Now, one of the things that a lot of people don't realize, I've got people come to me all the time, they say, I can't afford you, but can you help me with the paperwork? We've got a whole different type of fee schedule. If all we're doing is the paperwork, we're not going to court, we give them some general directions, we say we charge just for the amount of time that we help them, and maybe nothing more than looking at the form and saying, no, you need to do this here, you need to do that there. But after that, they're on their own. And certainly it's the least expensive way to go involving a lawyer. But don't necessarily try to do self-help unless you've done your homework.
Those rules, I just want to say something about those forms and things. There's, maybe a series of papers, and they just look like little boxes and insignificant. But if there's one that's supposed to be checked that there isn't, and the judges know which ones are supposed to be checked, you're going to have to start from scratch.
I saw in one particular case, this happened to be a family law case, where the lawyer started arguing about attorney's fees, and the judge looked down the paper and said, you didn't ask for them in your pleadings. End of discussion. That was, the lawyer didn't get paid unless his client, of course, paid for him. Understand, though, when you're talking about landlord-tenant law, that you're not entitled to a lawyer at public expense. Criminal law, yes. Some instances in other areas, but very rare. But you may qualify for a discounted rate under certain circumstances. But you're on your own for all intents and purposes, unless you can afford your own attorney. So it pays to do your homework. Can a tenant sue a landlord?
Now, there's real no counterclaim to this because the defense is whether there's been payment or not.
One of the things when I did a little bit of landlord-tenant work, we always told people that were the tenants, you have got one defense. You paid the money. And you better have evidence of it, like a receipt or a canceled check. But for the most part, the short answer is it's very difficult for a tenant to go after a landlord. Now, one area that they can is the 21-day rule. Once you've moved out, the landlord's got 21 days to tell you to return your deposit. If they go to the 22nd or 23rd day, even if there's damage to the house, the landlord may end up having to return the full deposit because they didn't follow the law. So know what you're doing. If also the landlord tries to evict a tenant illegally, they could be subject to a lawsuit. So there is.
Well, that's a whole nother civil action, and you could get in trouble quite quickly in that.
Right. Other areas that there are special rules. What if the tenant lives on a property and works for the landlord? Special rules. Mobile home parks, absolutely special rules. What if it's a residential motel? There are special rules. Landlord lives in a tax credit unit. Special rules. We've talked about the foreclosure. Short thing is talk to an attorney to figure out what your rights are, whether you're a landlord or a tenant. Don't try to do this on your own because you could end up in trouble.
These cases have priority in the courts because they involve people need to evict them to get them out quickly, and it's a quick process. So you got to know what you're doing in this area.
Absolutely. Talk to a lawyer. That's the best advice we can give you in landlord-tenant cases. Don't try to do them on your own. Thank you for joining us today.